All right, welcome to the Explainer. If you're deep in prep for the Queensland bar exam, then this one is absolutely for you. We're about to build a crucial part of your courtroom toolkit, how to prove official documents using the Evidence Act. This isn't just theory, this is practical, get-it-done advocacy. Okay, let's get right into it. So, picture this. You're on your feet in court. Your client's entire case, everything, depends on one specific government regulation. But the other side stands up and questions it. Is it real? Is that the exact wording? How do you get that piece of paper into evidence, quickly and without any drama? Sounds straightforward, right? But believe me, getting this wrong can absolutely tank your case.
You've basically got two ways to go here. The old way, the common law path, is, well, it's a nightmare. You're fighting hearsay rules, proving authenticity from scratch. It's a real swamp. But then there's the easy way. The Evidence Act 1977 gives us a whole series of brilliant shortcuts. Honestly, think of them as statutory cheat codes, designed to make your life as a barrister so much easier. And that's what we're going to master today.
So, where do we start? Well, let's go right to the top of the legal food chain, Parliament itself. How do we prove what our lawmakers have actually said and done? This is our first shortcut, and it deals with all that legislative material, covered mainly in Sections 44 and 47 of the Act. And here is the golden rule, and it's actually incredibly simple. Under Section 44, if you have a document, could be a bill, could be explanatory notes, Hansard even, and it purports to be printed by the government printer, that's it. That's the ballgame. You just hand it up, it's in, no need to call a witness to verify it, the document proves itself. And this is the magic of that word purporting. You're going to see it again and again. As the commentary points out, if a document just looks like an official publication, the court is bound to accept it as one. It's the appearance of officialdom that unlocks the shortcut. It creates this powerful presumption of authenticity that saves you so much time and effort in practice. All right, so that's Parliament sorted. Now let's move down a level to the executive branch. How do you prove all those proclamations, regulations, or orders that are made by the governor, a minister, or some other public body? Well, for that, Section 45 is our playbook. Now, the Act gives you options here, which is great. Section 45 actually lays out 5 different methods to prove these instruments. But for our purposes, and for what you're most likely to need in court, we're going to zero in on the most common and practical pathways. Just think of this as your practical checklist. First up, and often the simplest, just produce the relevant government gazette that contains the instrument. Job done. Second, sound familiar? A copy that purports to be printed by the government printer. That works too. Or for more specific instruments, you can use a certified copy. If it's from the governor and council, get it certified by the clerk of the executive council. If it's from a minister, get it certified by that minister. 4 clear, effective options. Okay, let's talk about a really crucial concept now, and it's a definite favorite for bar exam questions, the public document exception. This is a big one. It's a common law rule reflected in Section 48, and it's one of the major exceptions to the rule against hearsay. This is how you prove the truth of what's written in certain public records. So, what is a public document? The definition is super strict, and you have to tick every single one of these boxes. It has to be made by a public officer. That officer has to be under a duty to inquire into the facts and then record them. The record has to be for a public purpose, and, this is the most important part, it has to be reasonably available for public inspection. You might be asking, why does this exception even exist? What's the logic? Well, it all comes down to reliability. The thinking is that public access is the ultimate guarantee of a document's accuracy. The law makes what the commentary calls an optimistic assumption. Basically that if a record is open for anyone and everyone to see, any mistakes are far more likely to get noticed and fixed. That public scrutiny is what gives it its badge of trustworthiness. Now, let's nail down a very common point of confusion, a classic exam trap. Public document and official document are not the same thing. An official document is just a broad term for pretty much any document made by a public servant, but a public document is a very specific subcategory. It's an official document that is also open to public inspection. Think about it. Tons of official documents like internal government memos are definitely not public, and they don't get the benefit of this powerful hearsay exception. So what doesn't make the cut? Well, the cases give us some really clear examples. A plan of a subdivision that was privately prepared doesn't magically become a public document just because it's filed at the title's office. A famous, well-respected history book?
Nope, not a public document. And a record made by a foreign government for its own internal purposes, as the famous old case of Sturla ver Freytje established, that doesn't meet the test either. Okay, we've covered the main highways for getting these documents in. Now let's take a quick look at one special case before we lock in the absolute must-know takeaways for your exam. Right, Section 46. This is a neat little provision, and it's one of those handy tools to have in your back pocket, especially if you're doing negligence work. If a piece of legislation refers to, say, an Australian standard or some industry code of practice, this section lets you prove that standard just by producing a copy published by the standards body. It's a fantastic shortcut for proving compliance, or maybe more importantly, non-compliance with established safety rules. All right, let's boil this whole thing down. If you remember nothing else, tattoo these 3 points on your brain for the exam. Number 1, the Evidence Act is your friend. It's packed with shortcuts to get you around those common law nightmares. Number 2, the magic word is purporting. If a document looks official and comes from the right source, the court will presume it's valid. And number 3, know the definition of a public document inside and out, and never forget that public access is the absolute, non-negotiable, critical element. So we've spent all this time talking about how to get documents into evidence, but great advocacy, as you know, is a two-way street. So I'll leave you with this question to think about. Now that you know all the shortcuts to get a document in, what's your strategy when you're on the other side of the bar table? How do you attack your opponent's documents and argue to keep them out? That's the next level. Good luck with the study.